This is Bloomberg Law with June Grasso from Bloomberg Radio.
I do not believe that Richard Glossop is innocent. I believe him to be guilty, but I believe him to not have been given a fair trial.
This week, the Supreme Court threw out the murder conviction and death sentence of Richard Glossop. It was an extremely rare victory for a death row inmate at the court. But then Glossop's case was extraordinary in many respects. The state of Oklahoma appeared on the same side as the defendant, arguing that his 1997 murder conviction and capital sentence should be reversed because of prosecutorial misconduct. The Oklahoma Attorney General, Gentner Drummond, who supports the death penalty, had made an extraordinary concession known as a confession of error after investigating the case, including the documents that prosecutors had withheld from Glossop's attorney. He was represented at the court by former U.S. Solicitor General Paul Clement.
And General Drummond reached the conclusion, regretfully, but reached the conclusion, our prosecutors elicited perjury here and a man's going to go to his death. We can't allow that to happen.
The Supreme Court agreed that the prosecution had violated its constitutional obligation to correct the false testimony of its star witness, something that would have affected his credibility, as Justices Elena Kagan and Brett Kavanaugh pointed out during the oral arguments.
That seems pretty material to me. I mean, it's just your one witness has been exposed as a liar.
Would have made the conviction more likely if the jury knows that not only does he have an incentive to lie, that he's lied on the stand and that he's bipolar, therefore creating all sorts of avenues for questioning his credibility.
Richard Glossop has faced 9 execution dates during his more than 27 years on death row and came within hours of being executed in 2015, but prison officials discovered they'd been given the wrong mix of lethal drugs. He'll remain in prison as the state decides whether to retry him. Joining me is Cliff Sloan. He's a professor of criminal justice at Georgetown Law, who's argued death penalty cases before the Supreme Court. Cliff, this conservative court denies virtually all execution appeals. In this case, 2 conservatives, the Chief Justice and Brett Kavanaugh, sided with the liberal justices to make up the majority. The Oklahoma AG said he wasn't surprised by the ruling. Were you surprised?
No, I wasn't surprised by it, but I was heartened by it. I wasn't surprised by it because I thought on the merits, the case for Glossop in the Supreme Court was so strong, and it seemed in the oral argument that justices were clearly favoring Glossop's claim. A couple of them, Justices Thomas and Alito, were clearly hostile. And then there were a few that we couldn't really tell exactly. But as you said, the Supreme Court has been extremely hostile to claims raised by death row defendants in recent years. I think unfortunately so, and I think unjustifiably so. And so it was far from a sure thing that the Supreme Court was going to reach this decision.
Tell us about the majority opinion by Justice Sonia Sotomayor, where she focused on the state not correcting perjury by its star witness, the admitted hitman who got life in prison in exchange for his testimony.
One thing that's very unusual about Glossop's case is that you had the Republican Attorney General of Oklahoma, who generally is very much in favor of the death penalty, very strongly saying that he did not get a fair trial and that he should have a new trial, and that Glossop was right, that there had been prosecutorial misconduct that prevented him from having a fair trial and that required setting aside this conviction and this death sentence and getting a new trial. So you had a consensus by both Glossop and by the state. And yet, even with that consensus view, and even with the strength of their reasons for that, the Oklahoma Court of Criminal Appeals, the highest court in Oklahoma on criminal matters, rejected that position and said that the conviction is going to stand and he's going to be executed. And so it was this sort of remarkable situation where you had the state court rejecting the views even of the prosecutor, which was sharing the view of the defendant. Now, this is not the only time that this has happened in recent years. And one that got a lot of attention last year was the case of Marcellus Williams in Missouri, who had a strong innocence claim, and the office that had prosecuted him and secured the death sentence agreed that he should not be executed. And yet the Missouri courts rejected that, and the Supreme Court did not intervene. And that has happened in some other circumstances also. It actually reflects a kind of pervasive problem that we have right now when state courts are rejecting the consensus view of prosecutors and defendants that the individual didn't get a fair trial or didn't get a death sentence fairly imposed, and the state court just barrel ahead in upholding the conviction and ordering the execution.
Justice Sonia Sotomayor wrote the majority opinion in Glossop, and she focused on the state not correcting perjury by its star witness, the admitted hitman who got life in prison in exchange for his testimony.
Mr. Glossop wasn't involved in the actual, physical commission of the murder. And the case against Glossop depended entirely on the testimony of an individual who said that Glossop had recruited him to commit the murder. And there was no other direct evidence that Glossop was involved in planning the murder in any way. It came out later that the individual whose testimony was so critical in implicating Glossop, he lied on the stand, and that the prosecution knew that it was false testimony. And what it was about was that he had taken lithium, and he testified that he had never been treated by a psychiatrist, and he had no mental health problems, and that he had received the lithium as a mistake when he had requested something for a cold. And one of the things that came out years later, and that was kind of the heart of the case in the Supreme Court, was that the prosecutor had in her notes of a conversation with him a reference to lithium and to the name of the psychiatrist at the facility where he was being incarcerated, and the medical records reflected that he had been prescribed lithium by a psychiatrist and had bipolar disorder. And this would have been very, very important for the jury to understand, both in terms of his credibility. And again, the entire case against Glossop depended on his credibility. And here he blatantly lied about the circumstances of his receiving lithium and whether he had ever been treated by a psychiatrist, and also possible implications that they might draw about whether he would have acted impulsively and whether it could have been connected to his psychological difficulties. So it was extremely important evidence. That was the view of the majority. And there's a Supreme Court case going back to the 1950s called NAPU, which says that the prosecution cannot knowingly put on false testimony, and that if there is false testimony that the prosecution knows about, it has to correct that before the jury. And if not, it's a violation of the defendant's constitutional rights. It's a violation of due process. And so Glossop's argument, and the Oklahoma Attorney General agreed, is this is a classic open and shut NAPU violation. The only witness against him gave false testimony. We've got this evidence in the records that shows that the prosecutor, she knew it was false testimony, and yet she didn't do anything to correct it. So that was the view of Justice Sotomayor and the majority.
Justice Neil Gorsuch recused himself from the case because it had come before him when he was on the 10th Circuit. Justice Amy Coney Barrett concurred in part and dissented in part. And conservative justices Clarence Thomas and Samuel Alito dissented, which comes as no surprise.
Well, they generally have been extremely hostile to capital defendants. And even in a case where Justice Alito did join almost all of the other members of the court in ruling for capital defendants, he wrote a very narrow concurrence in the judgment where he basically said, this case and this case only. But that, brings up a very important point about the Supreme Court as a whole, because since the modern era of the death penalty began in the mid-1970s, there have been 200 people who have been exonerated on death row. That is a deeply troubling fact. And yet, the Supreme Court very regularly is raising and constructing extremely complicated procedural obstacles that make it very difficult and in some cases impossible for defendants to have federal courts examine the merits of their constitutional claims, even when those claims relate to innocence.
In Glossop's case, the next step will be for Oklahoma to decide whether to retry him. Here's what the AG said about that.
The facts are well developed at this point, but we need to look back on the evidence and see what evidence we actually have that we can go forward on and what witness recollection there is to make a determination on the efficacy of a jury trial.
How do you try a case 28 years later when there was never any physical evidence to begin with? Now there's new evidence that the state's star witness lied on the stand, wanted to recant his testimony so he can be impeached. I mean, how do you try a case like that?
I think it's going to be extremely difficult for them to try the case, and we'll see what charges they would bring for the reasons that you mentioned. Of course, it's a long time ago, but also it's the very reason why this information was so important, because the fact that the only witness against him blatantly lied, he is subject to impeachment on that basis. And so I would think there will be enormous problems in trying the case.
We'll see what Oklahoma decides. Thanks so much, Cliff. That's Professor Cliff Sloan of Georgetown Law. Coming up next, the court turns away cases on abortion buffer zones. I'm June Grasso, and you're listening to Bloomberg.
At long last, this national nightmare that we're going through will be over. Women will be happy, healthy, confident, and free. You will no longer be thinking about abortion because it is now where it always had to be, with the states and with the vote of the people.
But the so-called national nightmare is far from over. In fact, the fight over abortion rights is still front and center, as several states introduce bills to charge women who get abortions with murder. Others introduce bills to classify the most commonly used abortion drugs as dangerous controlled substances. And the decades-long fight over abortion buffer zones continues. This week, the Supreme Court dealt a setback to anti-abortion activists by refusing to reconsider a 2000 decision that lets states and cities create those protective zones to shield patients from being approached near clinic entrances. The justices turned away appeals over laws in New Jersey and Illinois that argued the buffer zones violate the free speech rights of abortion opponents who want to talk to women as they enter the clinics. Joining me is an expert in the law of reproductive rights, Mary Ziegler, a professor at UC Davis Law School. Mary, tell us about that decision in 2000 that these cases are trying to get overturned.
So this was part of a series of rulings on this topic called Hill versus Colorado. Hill was about a Colorado law that was kind of prototypical of the era that made it unlawful for anyone who was within 100 feet of a healthcare facility's entrance to knowingly come within 8 feet of another person unless the person they were approaching consented. And the idea was either to, show them a sign or talk to them or whatever. And a group of anti-abortion protesters thought that this violated the First Amendment, and they sued. And the U.S. Supreme Court, in a 6-3 ruling, held that Colorado's restrictions on this kind of speech-related conduct were constitutional. So this was a bid by the new generation of abortion opponents to get rid of this prior ruling.
I mean, I've wanted to get rid of it for a long time. This was the first time this has come up since the court overturned the right to abortion?
Yeah, it was. So the court had kind of narrowed the protections that it afforded medical facilities in a 2014 decision out of Massachusetts called McCullen. but the issue hadn't really returned to the court in a meaningful way since then.
As usual, the court gave no explanation for why it wasn't taking the cases. But do you think they just want to avoid another abortion case?
It's hard to say. It may be that they didn't want to take another abortion case. It may be that this was not the ideal case to take because Carbondale, which was the site of one of the ordinances that was being challenged, no longer was enforcing its ordinance. So there was an argument that this was no longer a real live dispute. If the justices do want to take up an abortion case, they may not want to take up a case that features protesters and potentially vigilantes, right, as opposed to abortion opponents who are claiming to interpret laws on the books rather than resist them. So it's hard to know how much to read into this. It may not be a sign that the court's reluctant to get into the abortion debate at all. It may simply be something unique to this case.
So the conservative justices Clarence Thomas and Samuel Alito said they would have heard both cases. And Thomas said in a dissenting opinion that Hill has been seriously undermined, if not completely eroded, and our refusal to provide clarity is an abdication of our judicial duty.
I think that Thomas's argument was that the court's subsequent decisions after Hill had afforded more protection for the speech of anti-abortion protesters. And I think Thomas was also stressing what had happened in Dobbs, the decision overruling Roe. So parts of Dobbs complained about what abortion opponents call abortion distortion, the idea that Roe had kind of deformed other areas of the law that weren't theoretically closely related to abortion. And one of the areas that Dobbs flagged was First Amendment doctrine and cited Hill as an example of this distortion. So Thomas pointed to this language in Dobbs and said, well, we already suggested that Hill was a distortion, so why don't we overrule it? That was the other, I think, inconsistency Justice Thomas was trying to flag.
It takes 4 votes to take the case, and you had 2 other conservative justices, Neil Gorsuch and Amy Coney Barrett, who had previously joined Thomas in criticizing the Hill ruling. So that would have made 4 votes. It seems odd that they didn't take it.
Yeah, I mean, like I said, there are any number of reasons. We know historically that the justices have sometimes been more uncomfortable with clinic blockaders and protesters than they are with other anti-abortion arguments, especially because there has been sort of a flavor sometimes from those protesters of answering to a higher law rather than to the Supreme Court. We also know, again, that this case had some sort of weird procedural issues that might have made some of the justices who weren't eager to get into this arena again anyway, might have given them an excuse to wait. So we might not know for sure, but again, I think it's much too early to say we won't see the court get involved in another abortion case in the near term.
So then is this a real setback for abortion opponents or not?
It's certainly a setback. I think there was a feeling that abortion opponents had when the court first decided Dobbs that it was kind of open season and that any precedent on abortion rights could be challenged and quickly done away with. And that's certainly not the impression that this gives. It seems that, you know, if for example, plaintiffs don't have standing, or if a case has defects like this one does, that the justices may just pass on it. I think it is a setback, but how significant a setback I think is challenging to determine.
I mean, are there a lot of prosecutions of protesters outside abortion clinics these days?
One of the, I think, obviously features of this is that there were relatively few, but there were some prosecutions under the Federal Freedom of Access to Clinic Entrances Act. And they're a relatively small percentage of prosecutions per protest. And of course, you know, we expect to see more of them because the Trump administration announced that they would not be enforcing the FACE Act against abortion opponents during the Trump administration, sort of regardless of what happens. So there already are protests, and we'd expect to see more. To some degree, they're also more concentrated, of course, because there are fewer places where it's possible to get a legal abortion and thus fewer clinics. So protesters can kind of concentrate on the remaining locations.
Has the Trump administration made any other moves regarding abortion?
Not a lot. So the Trump administration has made some of the kind of standard moves we'd expect to see from a Republican president on abortion. So, for example, reinstituting limits on foreign aid to NGOs that do abortion advocacy or referrals. We've seen coded references to the idea of fetal personhood in the gender executive order that the Trump administration handed down. As I mentioned, Trump and J.D. Vance made clear that there would be no more prosecutions under the FACE Act to protect access to abortion clinics or crisis pregnancy centers, interestingly. So we've seen that, but we haven't seen a lot of the bigger moves that abortion opponents have been hoping for. That doesn't mean we won't in the future, but Trump has yet to take action on those fronts.
What are abortion opponents targeting right now? Is the abortion pill mifepristone one of their targets?
The steps that they're primarily interested in are either imposing new limits on mifepristone through FDA or directly through HHS Secretary Robert F. Kennedy, or potentially even removing mifepristone from the market altogether. There's also a potential push to have the Trump Justice Department treat the Comstock Act as a de facto ban on mailing abortion-related items and to start prosecutions. Those are, I think, the two things that have captured the most attention. The other thing, of course, that will have a major impact but won't be as evident in the short term is that Trump will continue to fill judicial vacancies with conservative judges like Matthew Kacsmaryk and James Ho, who've issued pretty strongly conservative and sweeping rulings on abortion since Trump nominated them during his last administration. So I think the courts overall will probably be moving significantly to the right on these issues, but those are not impacts we'll see from the Trump administration in the coming weeks. That's a longer-term change.
As far as RFK Jr., is he a threat to abortion rights?
It's difficult, again, to say. So RFK had telegraphed during and after his confirmation hearing that he would be investigating the safety of mifepristone at Donald Trump's request. Now, abortion opponents, on the one hand, were excited about this because there's no real need to study mifepristone unless you're telegraphing a move to limit it. Mifepristone is one of the most studied and really regulated drugs in the United States. On the other hand, of course, the Trump administration has been perfectly capable of taking very quick action to establish policies it wants. And the fact that it's sort of slow walking these policies may mean that the Trump administration is simply trying to buy time rather than building toward a sweeping new abortion policy. So I think it's just too early to say which of those we're seeing.
It does seem like there's potential now for red state, blue state abortion battles. There's the first criminal indictment since Roe was overturned of a doctor who sent abortion pills across state lines.
I don't care what the laws are in the state of New York. Laws in Louisiana matter, and we plan to enforce them.
Louisiana District Attorney Tony Clayton has filed criminal charges against New York doctor Margaret Carpenter. But New York Governor Kathy Hochul rejected his extradition request in no uncertain terms.
Never, under any circumstances, will I sign an extradition agreement.
There are two cross-border disputes that have unfolded. Texas has already had a civil judgment, a default judgment against Dr. Carpenter from New York that it's going to have to try to enforce in the New York courts. And meanwhile, Louisiana prosecutors are trying to extradite that same New York doctor to Louisiana to face criminal charges. And we know that New York Governor Kathy Hochul has made clear that she has no plans to extradite Dr. Carpenter. So both of these cases seem likely to end up with disputes in federal court that will probably eventually make their way to the Supreme Court.
There must be a lot of doctors sending abortion pills through the mail. Is there a reason why they went after that doctor in particular?
I think it's largely just a function of what evidence they find. In the Texas case, a partner of an abortion patient who took her to the hospital when she thought she was experiencing complications went home, found the pills which Dr. Carpenter had prescribed. Remember, at this point in time, New York wasn't allowing for anonymous prescriptions, and then reported this to local law enforcement, which led to the complaint filed against her. In Louisiana, it seems to have been similarly coincidental. A woman ordered pills from Dr. Carpenter for her daughter. And when the daughter took the pills, when the mother wasn't home, she was worried about the bleeding she was experiencing and called 911. And law enforcement, again, found the pills with Dr. Carpenter's name on them. So I think there will likely be a certain amount of randomness in terms of who's targeted in these kinds of cross-border disputes, just depending on what law enforcement can actually uncover.
And this month, Governor Hochul signed a law that shields the identity of doctors in New York who prescribe abortion pills. Thanks so much for coming on the show, Mary. That's Professor Mary Ziegler of UC Davis Law School. Coming up next on the Bloomberg Law Show, the Supreme Court hears a case of reverse discrimination. I'm June Grasso, and you're listening to Bloomberg. Marlene Ames says she was denied a promotion and then demoted from her position at the Ohio Department of Youth Services because she's heterosexual, and that her employer put less qualified gay people in those jobs instead. But the Sixth Circuit Court of Appeals threw out her job discrimination case under Title VII, ruling that as a member of a so-called majority group, Ames needed to show background circumstances to support the suspicion that her employer is that unusual employer who discriminates against members of the majority. Here's how Justice Elena Kagan described the opinion.
I mean, I think that that's the absolutely critical language in this opinion. Because Ames is heterosexual, she must make a showing in addition to the usual ones for establishing a prima facie case. And then it says, Ames's prima facie case would have been easy to make had she belonged to the relevant minority group, here gay people.
Circuit courts covering 20 states impose this additional requirement when members of a majority group, including men, heterosexuals, and white people, allege workplace bias under federal law. They have to show background circumstances. For example, here that LGBTQ people made the decisions affecting Ames, or statistical evidence showing a pattern of discrimination against members of the majority group. Justices from across the ideological spectrum question the requirement that members of majority groups meet a higher standard to prove job discrimination than minority groups that have historically faced discrimination. Even the Ohio Solicitor General, Elliot Gazer, didn't defend the extra requirement under questioning by Justice Amy Coney Barrett.
We agree. Ohio agrees that it's wrong to treat people differently.
So if we said someone like Miss Ames, who is a member, it doesn't matter if she was gay or whether she was straight, she would have the exact same burden and be treated the exact same way under Title VII if she sued as someone who was gay and argued that they were discriminated against under Title VII. Same.
I think that she should have the same burden.
Justice Brett Kavanaugh suggested a straightforward way of resolving the case to the attorney for Ames.
So all you want for this case is a really short opinion that says discrimination on the basis of sexual orientation, whether it's because you're gay or because you're straight, is prohibited and the rules are the same, whichever way that goes.
That's right, Your Honor. And
that's all we need to say.
It was, for the most part, a rather lighthearted argument that lasted, and this is the only shocking part of it, 5 minutes under the scheduled time. Justice Neil Gorsuch summed it up.
Well, we agree that the court should say that at the very, very minimum.
But we're in radical agreement today on that, it seems to me. The counsel before us seem to be in total agreement.
Joining me is an expert in employment law, Sachin Pandya, a professor at the University of Connecticut School of Law. Tell us about the facts of the case, why the plaintiff was bringing this action.
The long and short of it was that the plaintiff here brought a lawsuit alleging that she was denied a promotion because she was heterosexual, that the promotion to a bureau chief position was in favor of a gay woman, and then later she was demoted from her own position in favor of a gay man. There's some other claims in the case as well, but this is the one Title VII claim that has made it up to the Supreme Court.
Tell us about this background circumstances requirement that Ames is challenging.
The background circumstances rule is a rule first adopted by the D.C. Circuit and then adopted by other circuits in evaluating the prima facie case in a situation where the plaintiff is a member of a majority group, a white plaintiff, for example, or in this particular case, a heterosexual plaintiff who is alleging discrimination based upon that heterosexual status. The courts in those cases say that you need something else. And that what's that something else? Some background circumstance, some additional item of evidence, which would support the inference that this was a kind of case where the employer was discriminating against the member of a majority group. When this plaintiff in the Ames case argued and provided some evidence to say, I want a jury trial on the question of whether or not I was denied a promotion because I'm a heterosexual woman and therefore discrimination on the basis of sexual orientation, the district court and then the Sixth Circuit Court of Appeals said, you didn't make out your prima facie case. Because you are a member of a majority group, you had to provide that additional background circumstances to show that this is the kind of case where the employer was discriminating against heterosexuals and in favor of gay people. And that reason the Sixth Circuit gave for refusing to let Ames's case go to trial is what she's challenging up at the U.S. Supreme Court.
Did it seem as if a majority of the justices were ready to throw out that background circumstances test?
Well, I can't read their minds, and I'm always a little bit wary of using what they say in oral argument as a crystal ball. It's not super predictive of much. But if I were to guess, there's not a lot of support on the court for keeping the background circumstances rule. And it's really just a question of how narrowly or how broadly they write the opinion that sends it back. My best guess, if I were a betting man, was to say that they're going to reject the background circumstances rule, but do they, in the course of doing that, also say some things about the scope of Title VII, which may, for example, implicate recent debates over permissible DEI? That's an open question.
There was no discussion of DEI during the oral arguments, and this comes at a time when there's a broad legal and political attack on DEI. Did you expect to hear some conversation about it?
I wouldn't have been surprised if there were, because after all, the key idea here on the part of the plaintiffs is that Title VII shouldn't apply any differently depending upon the identity of the plaintiff seeking redress. That is, it doesn't matter whether you're a racial minority or a majority, whether you're a woman or a man, whether you're a majority or minority plaintiff. Could I imagine that they could write an opinion that broadly, which implicates the scope of DEI? Sure, but I don't know that there's appetite to use this case to make that point.
Justice Amy Coney Barrett asked whether there'd be a flood of lawsuits if they get rid of this background circumstances test.
Counsel, what do you have to say to the department's contention that this is just going to throw the door wide open to Title VII suits? Because now everybody can say, hey, this was discrimination on the basis of race, gender, et cetera.
Do you think it would open the floodgates to more lawsuits from members of majority groups?
The short answer is no. Opening the floodgates presupposes that there's a lot of water waiting to go down the stream once the gates are open. And I honestly don't know how many majority group plaintiff lawsuits there actually are waiting in the wings, because my assumption is that most illegal discrimination occurs against the minority, not the majority. So if you accept that assumption, then there isn't a floodgates problem to worry about.
In this case, the employer, the Ohio Department of Youth Services, has already given a reason why they say Ames was demoted from her administrator position. They said she wouldn't bring a proactive approach to the department's increased emphasis on combating sexual violence in the juvenile corrections system. So what happens if the Supreme Court, as expected, sends this back to the lower court?
If and when this goes back to the lower courts, the plaintiffs will have an opportunity to show that there's enough evidence that the reason that they gave was a pretext and that the real reason was discrimination, that they ought to be able to get a jury trial on that question. That's what the plaintiff wants here. This is sort of not something that was talked about at oral argument because the Supreme Court is likely to rule narrowly. But Justice Kavanaugh, when he was on the D.C. Circuit, wrote an opinion that emphasized that if the employer has already provided a reason, courts ought not to bother making plaintiffs prove the prima facie case. All they should do is to say, is there enough evidence on summary judgment that the plaintiff can prove that the reason was a lie and that the real reason was illegal discrimination, that they get to have a trial on the matter. All this talk about the prima facie case is secondary. I don't know whether the court's going to write an opinion which goes that far, but it is certainly something that at least Justice Kavanaugh has written about.
How does a plaintiff like Ames show that she was fired because she was heterosexual and not because of the reasons given by her employer. In the absence of some blatant acts by her employer, it seems like providing evidence of the motive is difficult.
I think generally discriminatory motive is a hard thing to prove when you don't have somebody saying it on tape or something like that. Most kinds of discrimination claims rely upon indirect evidence of motive. That is, that you say that it's one reason, but your past conduct suggests that it's not, it's something else, that you may have treated people who are otherwise similar to the plaintiff more favorably, the only difference being that those other people were of a different race or gender. Those are the kinds of evidence that you would expect a plaintiff's lawyer to try and collect and at least try to persuade a jury, or at least try to persuade a judge to let them persuade a jury of discriminatory motive. It's not easy to prove discriminatory motive, but that's the kind of evidence that they would be looking for and pointing to.
Will this decision by the court have any implications for what I mentioned before, this attack we're seeing on DEI policies and programs?
I think it depends on how narrowly or broadly the court writes the opinion. If they narrowly write the opinion to say, going forward, when the plaintiff relies upon the McDonnell-Douglas framework, they shouldn't be required to prove background circumstances if they are a member of a majority group. And if they just stop there, it's going to have minimal effect on this larger conversation about the legality of DEI programs. However, if the court writes a broader opinion, which stresses that Title VII doesn't apply any differently depending upon whether you are a member of a majority group or a minority group, and in the course of doing so, is critical of the key U.S. Supreme Court Title VII precedent, which allows for some employer discretion to adopt what are called DEI programs. That's the United Steelworkers versus Weber case. Then it might have some bearing. But if they stay away from implicitly or explicitly criticizing the Weber opinion and write the opinion more narrowly, then it's not going to have, I don't think, that much relevance for that ongoing debate.
Thanks so much for joining me. That's Professor Sachin Pandya of the University of Connecticut Law School.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.